My grandfather built everything he owned with his hands before he ever touched a contract. Harold Whitfield started with a single hardware supply company in a mid-sized city in Ohio in 1971, and over the next 32 years he expanded it into a regional distribution operation that touched commercial construction projects in 4 states. He sold the company in 2003, reinvested the proceeds into commercial real estate, and by the time I was old enough to understand what wealth actually meant, he had accumulated a portfolio that included 2 commercial strip centers, a self-storage facility, 41 acres of undeveloped land in a corridor that planners were quietly eyeing for a highway expansion, and a primary residence in a neighborhood that had appreciated considerably since he purchased it in 1989. I am not telling you this to establish envy. I am telling you this because the size of the estate is what made the betrayal worth executing and what ultimately made it impossible to conceal. I am Marcus Whitfield. I am 31 years old. I work as a logistics coordinator for a freight company in Columbus, and I have lived there for the past 6 years. My grandfather and I were close in a way that his other grandchildren were not because I was his favorite in any soft, sentimental sense, but because I was the one who came to him with questions. I asked him how he structured his early vendor agreements. I asked him how he thought about depreciation on real property. I asked him to explain what his attorney meant when he said the phrase, stepped-up basis. He answered every question carefully, and I think what he valued in me was that I listened to the full answer rather than nodding and waiting for an opportunity to change the subject. We spoke by phone every Sunday. We had lunch in person 4 or 5 times a year. He told me, more than once, with no ceremony and no qualifier, that he had made sure I would be taken care of when he was gone. He died on a Tuesday morning in March. His housekeeper found him. He had gone to bed the night before after watching a baseball documentary, which was something he did often in the evenings. The cause of death was listed as cardiac arrest. He was 81. He had a pacemaker, a managed cholesterol condition, and the early stages of a neurological decline that his doctors had been monitoring for about 14 months. The decline was slow, his cardiologist said. The decline was manageable, his family physician said. He was not incapacitated. He was not institutionalized. He was living at home with assistance from a part-time housekeeper, and as of the last 7 months of his life, under the increasingly close supervision of my Uncle Gerald. Gerald Whitfield is my grandfather's only son. He is 59 years old. He lives in a large house in a suburb outside Cleveland, a house that my grandfather helped him purchase in 2008, when Gerald's own business, a commercial flooring installation company, ran into serious cash flow problems during the recession. Gerald recovered. The business survived, but the dynamic between Gerald and my grandfather never fully recalibrated after that loan. I know this because my grandfather mentioned it once, carefully, without names, when we were talking about what he called the weight of obligation. He said some people find a way to carry that weight, others let it turn into something else. My mother, Sandra Whitfield, was Harold's daughter. She and Gerald had not been close since their 30s, and the distance between them had become formalized over a dispute involving my grandmother's estate nearly 2 decades earlier. My grandmother passed in 2007, and there were disagreements about certain personal property and a small account she held independently. It was not a large sum of money, it was the principle of it, and what it revealed about Gerald's approach to anything that he felt entitled to. My mother stepped back from the family friction after that. She still maintained a relationship with my grandfather, though it was quieter and more limited in person, mostly phone calls and holidays. She did not pursue proximity to the estate or to Gerald's sphere of influence. She simply was not interested in the performance of family cohesion that Gerald and his wife Patricia staged at every gathering. I flew to Ohio the day after my grandfather died. My mother met me at the airport. We drove to the house together, and by the time we arrived, Gerald and Patricia were already there. Gerald had a key. He said my grandfather had given it to him for emergencies. I noticed even then that several filing cabinet drawers in my grandfather's study were partially open, and that a stack of documents that I remembered always being organized on the left side of his desk had been moved to a box near the door. I did not say anything. I was grieving. I told myself Gerald was probably just managing things, which was the most generous interpretation I could construct. The will reading was scheduled 8 days later. Gerald had arranged it through an attorney named David Holt, who had an office in a suburb of Akron. I had never heard my grandfather mention David Holt. My grandfather's attorney, the one I knew by name, because Harold had mentioned him with a particular kind of respect over the years, was a man named James Corley. Corley had been his attorney since the late 1980s. Corley had drafted the original will. Corley had been involved in the sale of the hardware distribution company. Corley had, according to my grandfather, reviewed every lease and deed before it was signed. When I asked Gerald who David Holt was, Gerald said James Corley had retired, and that my grandfather had transferred his affairs to Holt about 18 months ago. He said it the way people say things they have rehearsed. Smoothly, but slightly too smoothly. Like a sentence that had been shortened from something longer. The reading took place in Holt's conference room. It was a beige room with a round table and a credenza. Holt sat at one end of the table. Gerald and Patricia sat across from my mother and me. There was a fifth chair that no one sat in. Holt had a folder in front of him, and he opened it without introduction and began reading the document inside. He read it entirely before he stopped to summarize anything, which I later learned was unusual. Most attorneys pause to explain provisions as they go, to make the process accessible. Holt read it the way someone reads a prepared statement they hope no one will interrupt. The will was dated September 14th of the prior year. That was 9 months before my grandfather died. It named Gerald Whitfield as executor and sole primary beneficiary of the estate in its entirety, subject to a flat bequest of $15,000 to my mother, and a flat bequest of $15,000 to me. The real estate, the liquid investment accounts, the personal property, the vehicle, the residence, all of it went to Gerald. The document was signed and notarized, with 2 witnesses listed. I remember sitting in that chair and doing a kind of silent inventory, not of what I had expected to receive, but of the last conversation I had with my grandfather about this subject. It had been 14 months earlier, which placed it 3 months before this will was apparently drafted. He had called me on a Sunday, as he always did. He had told me with no particular gravity in his voice, that he had been making arrangements and that I should know I would be taken care of. He used the word meaningfully, not comfortable, not provided for, meaningfully. He said he wanted the things he had built to continue doing something useful after he was gone. He said he had talked to his attorney about it. He had been specific. He had said he wanted the self-storage facility to eventually become a source of income for me and my mother as co-beneficiaries of a trust he was establishing. He said the land was going to be held in trust for a period of at least 10 years because he believed in its long-term value and did not want it sold impulsively. None of that was in the document David Holt had just read. I did not react in the room. I asked Holt a question. I asked him whether this was the only will currently on file with the court. He said the will had not yet been submitted for probate but would be filed that week. I asked whether there were any trusts or related instruments he was aware of. He said not to his knowledge. I asked whether there was any codicil attached to the will he had read. He said no. Gerald was watching me the way people watch animals they believe to be penned. I asked one more question. I asked Holt when he had first been engaged by my grandfather. He said approximately 17 months prior. I thanked him and said nothing else. My mother and I drove back to her hotel in silence for the first 10 minutes. Then I told her what grandfather had said to me on that phone call. She said he had told her something similar. Not in those exact terms, but he had indicated that she would not be forgotten. Not $15,000, something that would carry weight. She said she had assumed Gerald would behave honorably, and had not wanted to press Harold for details because it felt like anticipating his death. I told her I understood that impulse, and then I told her we were going to need to find out what happened. That night I sat in my hotel room and made a list of what I knew in sequence. Grandfather had a long-standing attorney named James Corley. 14 months before he died, Grandfather told me he was working on an estate plan that involved trusts and specific designations. Approximately 3 months after that call, a new attorney named David Holt drafted a will that gave everything to Gerald. Holt said Corley had retired. The timing of the new will corresponded with the period in which Gerald had begun spending more time at the house, under the stated reason of helping Harold manage daily affairs. Harold's neurological decline had been documented as beginning roughly 18 months before his death, which meant it was already present, though early, when this new will was signed. I needed to know 2 things. First, whether James Corley was actually retired and what had become of Grandfather's files. Second, whether Grandfather had the mental capacity to execute a new will in September of last year. I did not sleep well. I was up before 6, and I drove to a coffee shop near the hotel to use the Wi-Fi and search for Corley's firm. The website for Corley & Associates was still live, but a notice on the homepage said the firm had ceased new client intake as of 16 months ago, and that existing client matters were being managed through a transition process. A phone number was listed. I called it at 8 that morning. A woman answered and said she was the office manager for the wind-down period. I told her who I was and that I was trying to reach James Corley regarding my grandfather Harold Whitfield's estate. She put me on hold for almost 4 minutes. When she came back, she said Mr. Corley was unavailable, but that she had taken my name and number and would pass the message along. Corley called me back at 11:47 that morning. He sounded older than I had expected, his voice deliberate, not frail. I told him who I was and he said he knew. He said Harold had spoken of me. I asked him directly whether he had retired and whether grandfather's files had been transferred. He paused before he answered. The pause was meaningful. He said he had reduced his practice significantly and was managing a limited number of long-standing matters. He said Harold Whitfield had been one of those matters. He said he had not transferred Harold's file to anyone and that Harold had not asked him to. Then he stopped and said he thought we should meet in person. I drove to his office the following morning. It was in a small converted house on a commercial street that had the feel of a neighborhood that had slowly transitioned from residential to professional. The sign on the door said Corley Law, in plain letters, no tagline. He met me in the entrance and walked me back to a room that was clearly a working office, not a showroom. There were stacks of files on shelves, a large printer, an older wooden desk, and 2 leather chairs in front of it. He sat behind the desk and I sat in one of the chairs. He had a folder in front of him. I noticed that the tab on the folder said Whitfield, H, and the folder was thick. He said he was going to tell me something that he had been waiting to determine the right moment to tell, and that my call had clarified that the moment was now. He said Harold had come to him 14 months ago and told him that Gerald had been pressing him to update his estate documents and had recommended an attorney named Holt. Harold had told Corley that he was not comfortable with that, but that he wanted to keep the peace with Gerald. Corley had advised Harold to keep his own counsel and to take no action he was not fully comfortable with. Harold had then asked Corley to do something. He had asked Corley to prepare a set of documents while Harold was still fully lucid, with full testamentary capacity, and to hold those documents in his office until they were needed. Documents that Gerald would not know about. Corley opened the folder, he turned it to face me. The top page was a cover letter on his firm's letterhead, dated 14 months prior. Below it was the first page of a trust instrument. Below that was an affidavit of mental capacity signed by Harold's neurologist at the time. Below that was a video recording disc in a paper sleeve, labeled in my grandfather's handwriting. Corley said Harold had understood that the neurological condition would progress, and that Gerald might attempt to use that progression as a window. Harold had known that Gerald had been monitoring the finances, asking questions he had no business asking, quietly positioning himself. Harold had also known that if he openly confronted Gerald, Gerald would accelerate whatever plan he was working on. So Harold had done what he always did with complex problems. He had worked around the obstacle quietly and left a record that would speak when he could not. The trust was a revocable living trust, executed 14 months before Harold's death, amended to irrevocable status by a signed rider prepared 8 months before death, at a point when Harold had told Corley he wanted to make the designations permanent. The trust transferred 4 specific assets into its ownership: the self-storage facility, the 41 acres of undeveloped land, a brokerage account valued at the time of transfer at approximately $840,000, and the primary residence. The named beneficiaries of the trust were my mother and me in specific proportions, with a professional trustee, a regional trust company, named to administer distributions according to Harold's written instructions. The trust also contained a no-contest clause, a spendthrift provision, and a specific provision stating that no subsequent will, whether or not purportedly signed by Harold Whitfield, could override the trust's asset designations for the funded assets, as those assets were no longer part of the probate estate. This was not a secret letter hidden in a mattress. This was a fully executed legal instrument prepared by a licensed attorney, signed in the presence of witnesses and a notary, with a concurrent medical capacity affidavit, placed in the custody of a legal professional who had been Harold's counsel for more than 3 decades. It was legally coherent, deliberately structured, and designed to survive precisely the kind of challenge that Gerald had apparently attempted. I asked Corley why he had not come forward immediately after Harold died. He said he had been waiting to understand what Gerald and Holt were doing. He said that if the assets named in the trust had already been removed from the estate in some fraudulent way, coming forward with the trust document would have created a different set of complications. He had been watching. He had seen the will reading scheduled through Holt. He had known that if I came to him, it meant someone was paying attention, and that the moment to act was when the opposing party believed they had already won. That afternoon I called Eleanor Marsh. My mother had a friend whose brother was an estate attorney in Columbus, and that friend had given me Eleanor's name 2 days earlier when I had mentioned, obliquely, that something about the estate situation felt wrong. Eleanor was 44 years old, a probate litigator with 12 years of contested estate experience. I explained the situation to her in detail. She listened without interrupting until I was finished, and then she said 4 words. She said, "Do not sign anything." She said she would drive to Akron the next morning. She said that based on what I had described, Gerald and Holt had approximately a 48-hour window before Eleanor could have a petition filed and an emergency order to delay probate distribution. She said the race had already started. I met Eleanor the following morning at Corley's office. She and Corley spent an hour reviewing the trust documents together, while I sat to the side and took notes. They spoke with the efficiency of people who had trained in the same system and understood the same language. Eleanor asked Corley several precise questions about the execution protocol, the notarial record, the capacity affidavit, and the mechanism by which the trust assets had been formally transferred. Corley answered each question directly. When Eleanor was done, she said the trust was valid on its face and almost certainly enforceable. She said the capacity affidavit from the neurologist was critical because it placed Harold in a documented state of full cognition at the time of execution, and because it would directly conflict with any claim Gerald might make that Harold had lacked capacity when he set up the trust. Eleanor then raised a separate question. She said that regardless of the trust, the will that Holt had read was still going to be submitted to probate, and it named Gerald as executor. That meant Gerald would have court-appointed authority over any assets not covered by the trust during the probate process. She said we needed to examine whether there were liquid accounts or other assets Harold had owned at death that were outside the trust, and whether Gerald had already begun moving those assets. She said financial institutions sometimes allow an executor designee to access accounts pre-probate if they present a death certificate and a draft will, which is a process that exists in a gray area that bad actors occasionally exploit. I called my grandfather's bank directly. I have his account number from a deposit slip he had mailed me years earlier when I had briefly helped him manage a property maintenance payment during a trip he was on. I gave the account number to the fraud department and said I was calling to flag a potential unauthorized access concern for an account belonging to a recently deceased customer. I was transferred 3 times. The third person I spoke to after I explained the situation and provided my relationship to the account holder said she could not confirm or deny account activity to someone who is not an authorized signatory. I understood, but I told her that there might be an executor designee presenting documents to access the account without a probate court order, and that I was asking her to flag the account for secondary review before any such access was approved. She put me on hold for 6 minutes. When she returned, she said the account had been internally flagged for the estate review process per their deceased account protocols, and that no disbursements would be made without court documentation. She did not tell me whether anyone had already attempted access. She did not need to. Eleanor filed the petition in the Summit County Probate Court at 2:47 that afternoon. The petition requested 3 things. First, that the court decline to admit the Holt will to probate pending review of the instrument's validity and the testator's capacity at execution. Second, that the court acknowledge and enforce the Whitfield Family Trust as the controlling instrument for the trust's designated assets. Third, that the court issue an emergency hold on all estate asset transactions pending review. The emergency hold was granted the same day at 4:15. The judge was not one I had met. Her name was Judge Miriam Rourke. The hold was granted by affidavit without a hearing, as is standard for emergency preservation orders in probate matters. Holt was notified by his office's fax and email within the hour. Gerald called my mother that evening. She did not pick up. He left a voicemail in a tone I would describe as controlled but pressurized, saying that he thought it was unfortunate that things were moving in a contentious direction, and that he hoped the family could resolve matters without courts getting involved in personal affairs. That voicemail was saved. I asked my mother to forward it to Eleanor, which she did. The first formal hearing was scheduled for 9 days later. In the interval, Eleanor filed a supplemental memorandum attaching the trust instrument, the capacity affidavit, the chain of title documents showing the transfer of the 4 trust assets into the trust entity, and a brief narrative of the timeline. She also subpoenaed records from Holt's office relating to the circumstances of the September will's execution. She subpoenaed the medical records from Harold's neurologist, covering the 12 months bracketing the will's signing date, and she filed a request to depose David Holt. Gerald retained an attorney of his own, a man named Raymond Castle, who had a practice in Akron and apparently specialized in probate matters. Castle filed a response to our petition arguing three things. First, that the Holt will was validly executed and should be admitted. Second, that the trust document was of unknown provenance and should be subject to authentication. Third, that the emergency hold was causing material harm to the estate by preventing necessary maintenance expenditures on the real property. The third argument was the one that struck me as both the weakest and the most revealing, because it acknowledged that Gerald had already been planning to make expenditures from the estate, and that being stopped was causing him inconvenience. People who expect to receive assets as a straightforward inheritance do not typically frame a court hold as causing harm to their plans. People who had already made plans for the money do. The 9 days before the hearing produced several significant developments. The first came from the neurologist. Eleanor's subpoena was answered by the doctor's practice with a set of clinical notes covering 14 months prior through 2 months before Harold's death. The notes from the September period, when the Holt will was signed, were particularly instructive. The treating neurologist had documented in her clinical notes from an appointment 11 days before the will was signed that Harold had shown what she described as increased susceptibility to external suggestion and a reduced capacity for sustained independent reasoning under conversational pressure. The note specifically mentioned that Harold had expressed during that visit some uncertainty about decisions being made around him by family members. The neurologist had noted that while Harold had not legally incompetent and could still process information when given adequate time and a low-pressure environment, he was vulnerable to what she called directed influence in high-stakes processations when he was fatigued or not fully prepared. 11 days after that clinical note, Harold had signed a will transferring everything to Gerald. The second development came from Holt's deposition. Eleanor conducted it in his conference room, the same beige room where the reading had taken place. Holt arrived with Castle beside him. Eleanor began with the basics and worked toward the specific. She asked Holt to describe the circumstances under which he had first been contacted by Harold Whitfield. Holt said Harold had called him. Eleanor asked whether Holt had any documentation of that initial contact, a phone record, an intake form, an email. Holt said the initial contact had been by telephone. Eleanor asked whether he had a phone record. Holt said he did not believe the record was retrievable. Eleanor produced a subpoena return from Holt's phone service provider showing call records for the relevant period. The calls that initiated the attorney-client relationship had come from Gerald Whitfield's personal cell phone, not from Harold's number. Holt said Harold had been with Gerald at the time and had used Gerald's phone. Eleanor asked whether Holt had verified Harold's identity directly. Holt said Gerald had vouched for Harold's identity during that initial call. Eleanor paused. She made a note. She moved on. She then asked Holt to describe the will execution meeting in September. Holt said Harold had come to the office with Gerald. Eleanor asked whether Harold had come in independently at any point, unaccompanied, to discuss the will's terms. Holt said Gerald had attended all meetings. Eleanor asked whether Harold had communicated the will's terms to Holt in a private session without Gerald present, as is standard professional practice for will execution to ensure the testator is not under undue influence. Holt paused. He said there had not been a private session. Eleanor marked that answer. She asked whether Holt had conducted any independent capacity assessment or referred Harold for one before execution. Holt said he had observed Harold during the meetings and found him oriented and communicative. Eleanor asked whether he had reviewed Harold's medical history or consulted with Harold's physician. Holt said he had not. Eleanor asked whether he had known about the neurological diagnosis at the time. Holt said he was not aware of a formal diagnosis. Eleanor presented the clinical notes from the neurologist, which showed that the diagnosis had been shared with family members and primary care physicians in a written summary 14 months before Harold's death. She asked whether Gerald, who had attended all of Holt's meetings with Harold, had disclosed this diagnosis to Holt. Holt said he did not recall that disclosure being made. That deposition transcript ran to 61 pages. Eleanor submitted a 14-page excerpt as an exhibit in the probate filing. The third development came from an unexpected source. Harold's housekeeper, a woman named Dora, had worked for him for 9 years. She had not been at the will reading. She had not been contacted by Gerald or Holt. Eleanor found her through a simple phone inquiry to the house's landline, which Dora answered because she was still handling maintenance and had a key. Eleanor asked her, with her permission, to provide a written statement about what she had observed in the months before Harold's death. Dora's statement, which ran to 3 handwritten pages that Eleanor had transcribed, described several things. She described Gerald visiting the house 3 to 4 times per week beginning approximately a year before Harold died. She described Gerald frequently being alone with Harold in the study for long periods, while Dora worked in other parts of the house. She described one specific afternoon when she had brought tea to the study door and heard Harold say, in a raised voice, that he did not want to sign anything else. She said Gerald's voice had followed, lower, slower, and she had not heard the words clearly, only the cadence of it. She said when she had entered shortly after, Harold had looked tired and there were papers on the desk, and Gerald had moved them to the side without looking at her. She said she had not known what to do with that memory until someone thought to ask. The hearing took place on the gray Thursday morning in the Summit County Courthouse. Judge Rourke's courtroom was smaller than I had expected, not a dramatic chamber but a workmanlike room with overhead fluorescent lights, and a bench that put the judge slightly above the floor level. Eleanor sat at one table with Corley beside her as a consulting witness. Castle sat at the other with Gerald. My mother and I sat in the gallery. Judge Rourke opened by reviewing the petition and the counterfiling. She said she had read both with care, including the attached exhibits, and she had several questions before she heard arguments. Her first question was directed at Castle. She asked him to explain to her satisfaction the protocol by which the will of September 14th had been executed, with particular reference to whether Mr. Whitfield had been seen privately and independently of any interested party by the drafting attorney before signing. Castle said it was common practice for family members to attend will signings. Rourke said that was not responsive to her question. She asked again. Castle acknowledged that Gerald had been present throughout. Rourke said, "Throughout, meaning the signing and all preparatory discussions?" Castle said that was consistent with his client's recollection. Rourke made a written note. She did not comment further. Her second question was directed at Holt, who was present in the gallery, and she called him forward to the witness area. She asked him directly whether he had known, at the time he oversaw the will's execution, that the testator had an active neurological diagnosis. Holt said he had not been informed. Rourke said, "Had you inquired?" Holt said he had observed Harold to be capable at the meetings. She said, "I understand what you observed. Had you conducted or requested an independent capacity evaluation?" Holt said he had not. She said, "In a case where the estate value exceeded $2 million, and the beneficiary designation represented a complete alteration of an existing estate plan, you made no inquiry into medical history and no independent capacity assessment." Holt said he had used his professional judgment. She looked at him for a moment and then looked back at her notes. Eleanor presented arguments for approximately 40 minutes. She walked the court through the trust execution timeline, the capacity affidavit from the period in which Harold was fully lucid, the clinical notes showing the decline in independent reasoning capacity in the weeks before the September will was signed, the deposition showing Gerald's consistent presence at all Holt meetings, Dora's statement about what she had heard in the study, and the phone records showing it was Gerald who had initiated the attorney-client relationship with Holt on Harold's behalf. She did not use the word fraud. She said the preponderance of documented evidence established that the will of September 14th had been executed under conditions that fell below the legal threshold for valid testamentary execution, and that those conditions were not accidental. She said the trust instrument, executed when Harold was in full legal capacity, with medical documentation, with independent legal counsel unconnected to any interested party, represented Harold's true and deliberate testamentary intent. Castle argued that the trust had not been publicly recorded, that its existence had been concealed from the family, and that concealment itself suggested irregularity. Eleanor responded that private trusts are not required to be publicly recorded or disclosed to family members, that the requirement for validity is execution and funding, both of which had occurred, and that characterizing a deliberate privacy measure as suspicious was precisely what a party who had been deliberately excluded from that measure would prefer the court to believe. Rourke then said she had one final matter she wanted to address. She said she wanted to view the video recording referenced in Corley's attached exhibit list. Corley had disclosed the disc in his exhibit set. Eleanor had a certified copy on a drive. Rourke's clerk played it on a court-approved device, and the room watched a recording of my grandfather. He was seated in what I recognized as Corley's office in one of the leather chairs. He was dressed in a collared shirt, his posture upright. He looked directly at the camera. He said his full name. He said the date, which was 14 months before his death, placing it at the period of the trust's execution. He said he was making this recording at his own request, in the presence of his attorney James Corley, to clarify the intentions behind the trust he had just executed. He spoke slowly and clearly. He said he was doing this because he had concerns about what might happen after he was gone. He said Gerald had been good to him in many ways, and he did not wish to speak ill of his son, but he also understood Gerald's relationship to money and to ownership, and he wanted to be certain that certain things went where he had always intended them to go. He looked at the camera and said my name. He said my mother's name. He said that the self-storage facility, the land, the brokerage account, and the house were designated for us because those were the things he had built with intentions that extended beyond his own life, and that he trusted us to carry those intentions forward. He said the remaining liquid assets and the commercial strip centers which were not part of the trust could pass as the law determined appropriate, and he was not prepared to create further conflict around them. Then he said one more thing. He said, if you are watching this, it means something went wrong. It means someone tried to make sure you would never see it. And it means that person forgot that the things built carefully always outlast the things built quickly. The room was quiet for a moment after the recording ended. Gerald, who had been watching from his table, did not move. Patricia, who was in the gallery, was looking at her hands. My mother was next to me, and I was looking at the wall in front of me, not because I was suppressing emotion, but because I was cataloging what had just happened. My grandfather had understood the threat, prepared for it, documented against it, and handed the documentation to the one person he trusted to hold it securely. He had not hired an investigator, he had not made accusations, he had signed a piece of paper, spoken into a camera, and given both to his attorney. He had used the system the way the system is supposed to be used, by a person who understood that systems run on records, not on feelings. Judge Rourke called a brief recess. When she returned, she said she had sufficient evidence to issue a preliminary ruling, and would do so now with full written opinion to follow within 10 business days. She said the will of September 14th would not be admitted to probate at this time, pending a full capacity hearing at which the attending neurologist would be called to testify. She said the Whitfield Family Trust was recognized as a valid instrument, and that the named corporate trustee was authorized to proceed with trust administration for the 4 designated assets, effective immediately. She issued a formal asset preservation order covering all remaining estate assets pending the capacity hearing. She directed Gerald to provide within 5 business days a full accounting of any transactions he had conducted involving estate assets between the date of Harold's death and the date of the emergency hold. She looked up from her notes. She said that the pattern of conduct described in the exhibits, specifically the substitution of independent counsel with an attorney, retained under the influence of an interested party, the exclusion of the testator from independent consultation, the failure to disclose a known medical diagnosis, and the execution of instruments that reversed decades of expressed estate planning under those conditions, would be examined with care. She did not use the word undue influence in that moment. She did not need to. The phrase had been in Eleanor's brief, and it would be in the written opinion, and both Castle and Holt knew exactly what it meant. Gerald left the courtroom without speaking to me. Patricia followed him. I did not look after them. My mother stayed seated for a minute after they left, and I sat beside her. Neither of us said anything meaningful. We did not celebrate. There was nothing to celebrate yet. The ruling was preliminary. The full hearing was still ahead. But the emergency hold was in place. The trust was recognized, and the most important asset, the record itself, was now part of a court proceeding that Gerald could not quietly close. The capacity hearing took place 31 days later. The neurologist, Dr. Anita Rowe, was called as an independent expert witness. She reviewed the clinical notes from the period in question and provided testimony. She said that the documentation she had produced in the weeks before the September will signing indicated that Harold had been in a period of cognitive vulnerability. She distinguished between legal incompetence and susceptibility to undue influence. She said Harold could, in a quiet room, with time, with no pressure, understand and express his wishes coherently. She said Harold in a room with his son, with papers in front of him, with months of consistent pressure and reshaping of his daily environment, was a different situation. She said the condition she had documented made Harold specifically vulnerable to the kind of slow, patient, environmental influence that produced compliance that looked like consent. Eleanor asked her directly, "In your professional opinion, does the clinical record support the conclusion that Harold Whitfield had the capacity to execute a will in September of last year that reflected his free and independent testamentary intent?" Dr. Rose said, "No, in my professional opinion it does not." Cassell cross-examined her for 40 minutes. He asked her whether Harold had ever been formally adjudicated incompetent. She said no. He asked whether she had been present at the will signing. She said no. He asked whether it was possible that Harold had experienced a period of clarity on the specific day of signing. She said it was possible, that possibility could not be verified and was inconsistent with the documented trajectory. Castle also called 2 character witnesses, both of whom were business associates of Gerald's, both of whom testified to Gerald's general dedication to his father's welfare. Eleanor's cross-examination of both witnesses established that neither of them had visited Harold at home in the 12 months before his death, that neither had personal knowledge of Harold's mental state during that period, and that both had business relationships with Gerald that created an interest in his favorable outcome in this proceeding. The court also received the financial accounting that Gerald had been ordered to produce. It covered the 17-day period between Harold's death and the emergency hold. During that period, Gerald had transferred approximately $214,000 from a joint savings account that he had been added to as a co-signatory roughly 11 months before Harold's death. He had also contacted a commercial real estate broker to initiate a listing inquiry on the self-storage facility, which was one of the 4 assets now held by the trust. The broker had a written communication from Gerald on an email chain that was preserved, in which Gerald stated that the property was expected to be available for sale within 60 days of a family situation being resolved. Eleanor introduced the email chain as an exhibit. She noted that the property Gerald had attempted to list for sale was already legally titled to the Whitfield Family Trust, and could not have been listed or sold by Gerald, regardless of any subsequent action, and that Gerald had either not known about the trust at the time of that inquiry, or had known and had proceeded anyway. Neither explanation reflected well on his conduct. Judge Rourke's written opinion arrived 13 days after the capacity hearing. It was 42 pages. I read all of it. I will summarize the most consequential findings. The court found that the will of September 14 had been executed under conditions constituting undue influence, based on the combination of the testator's documented cognitive vulnerability, the complete absence of independent consultation, the controlling presence of the primary beneficiary throughout the drafting and execution process, and the execution's direct and total contradiction of the testator's expressed intentions as documented in a prior instrument, prepared under independent and uninfluenced circumstances. The will was not admitted to probate. The Whitfield Family Trust was affirmed as the controlling instrument for its designated assets. The corporate trustee was authorized to proceed with full administration. On the question of the $214,000 transferred from the joint account, the court referred the matter to the county prosecutor's office for review under the Elder Financial Exploitation Statute. The court found that the timing, the amount, and the circumstances of Gerald being added as a co-signatory in a period when Harold's capacity was already in documented decline raised questions that went beyond the scope of probate proceedings. It was not a criminal conviction, it was a referral. But a referral from a probate court judge, based on a 42-page opinion detailing the full sequence of conduct, is not a routine administrative matter. The trust administration began within the following week. The corporate trustee sent formal notices to all relevant institutions. The 4 assets transferred without legal dispute because the title work Corley had done 14 months earlier was clean. The self-storage facility remained in trust. The land remained in trust. The brokerage account transferred to the trust's designated custodian. The house, which was listed in the trust instrument for sale at market value with proceeds, distributed according to the designated schedule, was appraised and listed within 30 days. It sold in 6 weeks. For the assets outside the trust, which included the 2 commercial strip centers and the remaining liquid accounts after the transferred funds were restored through a separate civil claim process, those were subject to probate as the video recording had anticipated. My grandfather had said he was not prepared to create further conflict around those assets. The intestate succession laws of Ohio, combined with the absence of a valid will, determined their distribution. Gerald, as a surviving child, received a share. My mother received a share. I received a share as a grandchild in representation of the deceased branch. It was not a windfall, it was a proportion. But it was legally correct, and it was arrived at through the process my grandfather had understood would be the fallback if everything else was contested. The civil recovery process for the transferred funds took an additional 4 months. Gerald's attorney negotiated a settlement rather than go to a full civil trial. The funds were returned to the estate. Gerald paid legal fees on both sides as a condition of that settlement. He did not admit wrongdoing in the settlement agreement. Settlement agreements almost never include admissions of wrongdoing. But the 42-page opinion in the probate record is a public document. It contains the court's findings. It will be there for anyone who looks. I went back to Columbus 11 weeks after the first hearing. I did not move back to Ohio. I did not leave my job. I did not change my daily life in any dramatic way. The trust produces distributions according to a schedule that my grandfather had laid out with care, reasonable, structured, not extravagant. The self-storage facility generates income. The land sits and waits as he intended it to. The brokerage account is managed conservatively. None of it requires me to make decisions impulsively or to upend a life I had built independently. That, I think, was exactly what he intended. He had not wanted to make me wealthy. He had wanted to make me stable. I spoke to Corley once more after the probate matter closed. He called me to say that the administrative wind-down of his firm was complete, and that he was formally retiring. I thanked him. I said he had held something important for a long time under pressure that most people would not have wanted. He said my grandfather had trusted him with it, and that there was no complexity in that for him. He had simply done what the relationship required. I think about the 9-day gap between when I sat in Holt's conference room and heard the wrong version of my grandfather's wishes, and when Corley called me back and I understood that the right version still existed. Those 9 days felt longer than they were, not because of grief, which was present, but separate from the situation, but because of the particular weight of being told that a person you trusted did not include you in the things they built. I know now that he had. The document said so. The recording said so. The court eventually said so. What I want to say carefully here, without exaggerating it, is that this resolution was not dramatic. It was procedural. It was the result of a man who had spent 50 years studying contracts and titles and records, understanding that the same discipline that had built the estate would also be required to protect it. It was the result of an attorney who had kept a file closed and waiting in a quiet office on a commercial street, and had answered a phone call from someone he had never met. It was the result of a probate court conducting the kind of review that probate courts are specifically designed to conduct, and a judge who asked the right questions and read the exhibits carefully. It was the result of a housekeeper who told the truth when someone asked. It was the result of phone records, clinical notes, deposition transcripts, and a video recording of a man sitting in a leather chair and speaking directly and calmly about what he wanted. None of those things are extraordinary. They are just what happens when a process works the way it is supposed to. What was extraordinary was that my grandfather understood far enough in advance, and with enough clarity about what was coming, that the process would only work if he built the record before the pressure arrived. He did not wait for the threat to become visible. He built the countermeasure before the threat fully materialized, because he had watched enough of the world to know that the kind of pressure Gerald would apply does not announce itself. It arrives gradually, in small adjustments to the daily environment, in gentle redirections of attention, in the slow replacement of independent counsel with counsel that an interested party has arranged. He had watched that pattern before, in business, and he had learned from it. He had applied that learning to his own situation quietly, and then he had died, and then the pattern had arrived exactly as he had anticipated, and the record he had prepared had been sufficient to stop it. I do not know what Gerald's internal accounting of all this looks like. I do not need to know. The sequence of events is documented in public filings. The financial exploitation referral is on record. The settlement is on record. The probate court opinion is on record. Whatever Gerald believes about his own intentions, or his own justifications, is a private matter that the records do not particularly care about. My grandfather did not leave me money in the way that some people might have expected, in a simple bequest, a clean line in a will, a number next to a name. He left me a structure, a trust. A framework built to operate without constant supervision, to produce consistent results over time, to withstand attempts to alter it, to wait through slow periods and not panic, and to be administered by a professional entity that had no personal stake in the outcome. He had built his business the same way. He had told me that once. He had said the best structures are the ones that work even when you are not in the room. He had been planning to not be in the room for a long time. He had made sure the structure was ready before he left. If any of what I have described here resonates with you, it may be because you have been in a room where someone read the wrong version of something that should have been yours. Or, you may be watching this because you know someone in that room right now. What I would tell you is what Eleanor told me in the first 20 minutes of our first conversation, before she had reviewed a single document. She said, "The most important thing you can do right now is find the record. Not because records are infallible, because records are what exist when everything else becomes contested. Documents do not remember things selectively. They do not adjust their accounts to match what is convenient. They say exactly what they were asked to say at the moment they were prepared, and that moment is preserved." My grandfather understood that. He spent a Sunday afternoon in an attorney's office, answered some questions, read some documents, spoke to a camera, and then went back to his life. 14 months later, that afternoon was the most important 2 hours of the entire story. Not the dramatic moments, not the courtroom, not the grief, not the conflict. The quiet afternoon when the record was made. I have thought about that quite a bit. I have thought about what it means to live the kind of life that produces that kind of foresight. Not dramatic foresight, not paranoid foresight, just the calm, methodical habit of building documentation the same way you build anything else worth having, before you need it, while conditions are still favorable, in a form that will hold up under the conditions that are less favorable. That is what this was. That is what I carry from it. If you want to know more about how these proceedings work, about probate, about trust formation, about what contested estate situations actually look like from the inside, the comment section will have those conversations. There are people in it who have been through versions of this, and the details matter because every situation is specific. I am not an attorney, I cannot give legal advice. What I can tell you is that Eleanor and Corley did their jobs because they were the right people in the right positions with the right records in front of them, and the outcome followed from that. The system worked because someone had done the work in advance to make sure the system had something to work with. If this story gave you something to think about, stay close. There are others like it, not because the world is full of bad actors, though it has its share, but because the gap between what people intend and what systems record is where most of these stories happen, and closing that gap is something anyone can learn to do. My grandfather learned it in hardware supply and commercial real estate, and 40 years of signed contracts. He passed it to me in 14 months of Sunday phone calls, and one careful afternoon in a quiet office. I am passing it to you in the only form I know how to use, which is the same form he used. A record. A clear account. Words in order, with the receipts attached. That is the whole story. That is how it ended. With a file and the right person to open it.